26 DCCR 0210 and 0211. Ms. Riley entered pleas of guilty in each of those, which are theft of property with previous convictions. The agreement on all of these was for a cap of 15 months in the state jail prison. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor.
Yes, Your Honor, we have.
Any additions or corrections?
Not from the defense.
Nothing from the state, Your Honor.
All right, Mr. Rojas, you may proceed.
Thank you, Judge. I know it's a big ask, Judge, and it's not something that the court, I think, probably is leaning toward. We're asking the court to consider probation in all these cases. Ms. Riley is 27 years old. She's got 2 young kids at home. As you can see from the PSI, most of her previous offenses are theft or some type of deception cases. And certainly she's old enough to know better. She should know better. I think if you look closer at her background, it's a situation where she never really had a chance to get any kind of direction in her life. She was placed in the CPS custody when she was 3 months old. I think she lived with her aunt until she was 14. I think all that time, or most of that time, her mother was in prison. And when her mother got out of prison, Ms. Riley went back to live with her mom. From 14 to 17. At 17, she ran away from home. And I think her father's in prison now. I don't know how long he's been in prison, but he's in prison now. I think the easy thing to do is to go ahead and send her to the state jail. Not only for the court, the easy thing for Ms. Riley would be to send her to the state jail so that when she gets out, her slate is clean. She starts all over. I don't know that that's going to, I think if that happens, Judge, she's probably going to be back in the same place she's at, committing offenses, committing more thefts. What I'm asking the court to do is consider probation with possibly ISF, the cognitive track of ISF, so that she can get some direction, hopefully start learning how to make better decisions, and get her life onto the right track. And I think, do you want to say something to that? At the appropriate time, she wants to say something.
Go ahead.
No, I have had time to sit and think about my consequences. I wanted to I have talked to my aunt that I was staying with at first. She said that I could come back to stay with me and my 2 children. She's willing to help me try to get a GED and to get into the infirmary and the plant, like the refinements. So.
You need to look back. The NTRP case for me. How long she sent it? All right, Mr. Nichols.
Judge, I think the 15 months is appropriate in this case. Her misdemeanor history is incredibly extensive, lots of thefts, lots of probations that have been revoked. And if you follow the timeline, it's for committing thefts while on those probations, which is what she did here. Two new thefts, 6-7 months after being placed on probation for theft. So I think given her criminal history and continuing to commit crimes while on probation, I think 15 months state jail is appropriate.
Give me just a second. I want
To this case?
No, I'm wanting to know, and it's not really going to make a big difference, but you know, she says she's had time to sit and think. And what I wanted to know was how long she had to sit and think before she took the probation on the case she's on right now.
I can go back and look it up if you need it.
But so Miss Riley, you were on probation. You've had 1, 6, 7 probations. 7. You were given a probation for this felony, and 4 months later, you picked up 2 new theft cases. You've had every opportunity for whatever help it is that is out there. It's not like you've just taken time and not had opportunities with probation to help you. And so at this time in cause number 24 DC, excuse me, 24 DCCR 1778, I'm going to find that you entered your pleas of true, freely, and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of theft of property. Sentence you to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 26 DCCR 0210. Find that you pled guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of theft of property. sentence you to a term of 15 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in clause number 26, DCCR 0211, find sufficient evidence to find you guilty of theft of property, find you guilty of that offense, sentence you to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm handing you the trial court certifications in each of those cases that shows that these were agreements that I followed, so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. There's a real easy way for you to stop being incarcerated, and that's to stop stealing. You can't expect to keep doing the same thing and not have more harsh consequences. And so you need to understand that when you get out of state jail, if you do this again, it's going to get worse every single time. So if you want to be there for your kids and break the cycle, then that's going to be up to you to break that cycle. All right. Back with the bailiff. Charles Verdine.
Carlson, A.
Charleston A. Verdine. Charleston A. Renee Verdine.
You had Charles Verdine.
We've already met.
I have. This is okay. This is. Charleston A.
Got all the Verdines.
Mm-hmm.
This one.
Welcome to the court.
Yeah. Well, good morning, ma'am. Are you Charleston A. Verdine?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion?
She will, Your Honor.
And Judge, the reason for this offer, if the court is inclined to follow it, just so you know, the motion was actually filed 10 days before she was set to expire out completely. So we're just trying to double back and address the addiction issue.
All right, Ms. Verdine, in cause number 22-40028, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 25th of 2023 for the third-degree felony offense of obstruction or retaliation, and that was a 3-year deferred probation. Is that correct? The motion alleges that you violated your probation. Is that 1 through 5?
It is, Your Honor.
Count 1 alleges that you provided a urine sample June 26th, October 15th, and November 17th of 2025 that tested positive for tetrahydrocannabinol. And is that true or not true?
Yes, ma'am. True.
That's marijuana.
Yes, ma'am. True.
Okay. Count 2 alleges that you failed to successfully complete the GED program as directed. Is that true or not true?
True.
Count 3 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you tested positive for alcohol June 26th and October 15th of 2025. And is that true or not true?
True.
Count 4 alleges that you failed to submit to alcohol or drug screening October 14th of 2025. And is that true or not true?
True.
And then count 5 alleges that you failed to successfully complete the moral recognition therapy program. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement is for me to continue your probation and extend it for 2 years. Order that you enter and successfully complete the JCDI program, which would also include a drug patch. Is that your understanding?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted any evidence that Ms. Verdine is not competent.
Oh, Your Honor.
So I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I do want to get an updated report. So we need to figure out between now and then what I can do between now and then. I just want to make sure that probation also agrees that that's all of the treatment and everything that's necessary. I'm willing to set a bond, and she's on probation. She can go ahead and start those programs, but I want to make sure, I think that we're covering everything, if that makes sense.
Judge, she's been incarcerated for a while. Would the court consider PR?
Yeah, okay, so what I'm gonna do, Ms. Verdine, is I'm going to reset your case for sentencing. I'm not gonna sentence you and extend it today. We're gonna do that later. But I am going to reduce or set a bond for you in the amount of $1,000, but make that a personal bond, which means you don't have to pay any money. You're just gonna get out of jail. You're still on this probation. You're required to do everything, including starting that JCDI program. You have to have a drug patch on within 24 hours of your release from custody. If you don't do that, I don't have to go along with this agreement when you come back. If you test positive between now and then, you're going to be right back in jail. Do you understand?
Yes, ma'am.
You can talk to your probation officer about where to get that drug patch. They'll help you with that, and then we'll see you back at sentencing, okay?
Yes,
All
ma'am.
right, you can go back with the bailiff.
I have a question.
Hang on just a second.
Is the drug patch right now just gonna be a condition of a bond? Or,
It's going to be both.
okay,
It needs to be a condition of probation and bond. Yes, ma'am.
I forgot what I was saying.
Sorry.
So I forgot.
Okay, if you think of it, Mr. Rojas will be around. You can tell one of the bailiffs. All right, you go back to the bailiff.
Judge, may I report?
Yes, ma'am, in just 1 second. Let me write this down before I forget. Yes, ma'am.
That Judge, I'm understanding he's on vacation this week.
Okay.
So if we could reset 1 week, he said he'll be back Friday, so.
Let's reset it 2
And
weeks.
he's hired misdemeanors.
Let's reset it
I
2
know,
weeks.
But really one is to be. So. Ashley still in this, but Altman has to plead him on his misdemeanor.
On Daniel Eli, we're gonna do 2 weeks, because if we just do it a week, he's not gonna have time. And if he goes and takes care of it, you can just dismiss it without him coming back here. Okay?
Yes.
Okay. That's Daniel Eli.
Yes, ma'am.
And then Anthony James.
Yes, Your Honor, if, we've received an offer, an adjusted offer, if we can have like just 2 weeks or so for him to get with his family, it's a TDC.
Okay. We're gonna reset, we'll reset James a couple of weeks. Mr. Lewis, you have 10 fam?
Yes, ma'am.
Are they all state jails?
Yes, sir.
Enhanced at all?
No, I think he has, anything done hands on. But they're stackable.
Those are all different dates.
Yeah.
And y'all have talked about that?
Yes.
Okay. Good morning. Are you
Good
Tan? You're Tan Van Fam?
Yes, ma'am.
And Mr. Pham, you are charged in cause number 25 DCCR 0909 with the state jail felony offense of theft of property from May 3rd of 2025. If you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years in state jail prison. Do you understand?
Yes. Depend on my lawyer. If she say yes, I have to say yes, ma'am.
No, I want to make sure you understand. And
I-
do you understand? Do you need an interpreter? Would that be better?
Yeah, that's better because I don't understand it very well.
Well, we've been able to communicate,
You have
you know,
the
fine.
whole time.
Yeah, yes, ma'am.
So, Mr. Fan, if you go, I just want to make sure in all of your cases, every single case, you've got 25 DCCR 0909, 25 DCCR 1039, 26 DCCR 0353, 54, 55. And then we've got 25 DCCR 0782 and 0785. All of those cases charge you with theft of property with previous convictions, which means if you're found guilty, the range of punishment, you could go to prison for a minimum of 6 months up to 2 years in each of those cases. Do you understand that?
I know, but I don't do like that, you know.
I just want to make sure you understand that
Right.
if a jury finds you guilty, what the range of punishment is,
I
what could happen?
I don't know what it means because my English not too well, you know. But I don't do like
We're
that.
going to reset it 1 week. Let's get, figure out who we can get as an interpreter, please. You speak Vietnamese?
Yeah, I speak with them.
Okay, we'll see you next week. We'll figure it out.
Okay, thank you, ma'am.
Yes.
Thank you so much.
I don't know, yeah. And then Mr. Rojas, Justice Lars,
Yes, yeah, he wants to talk to the-
he wants to do what?
talk to the court again. He wouldn't.
Let's get Mr. Larzo out real quick, please.
Mhm. Maybe if I lick you off, it'd be very. That's what it is.
You see, like the price is right. Remember that day when the little guy goes.
The
You're
mountain
like,
climber.
Little mountain man's going.
There's so many words are allowed. Yeah. All right, Mr. Larzo, what's going on?
I'm going ahead. I want to request a new lawyer. He's not
So,
representative.
here's the thing, you don't get to do that. So here's where we are. Mr. Rojas is a great lawyer. He's not, just because
Can I
he's,
speak?
nope, not while I'm talking. I already gave you an opportunity earlier and I'm gonna give you an opportunity in a minute, but I want you to listen carefully to what I have to say first, okay? Mr. Rojas is telling you what the district attorney's office is offering. You don't have to like it. It doesn't mean he's a bad attorney. And another attorney is not going to come get a different offer.
Okay.
So, Ms. Malfino, is there any reason that you would know of that offer that you have made would change?
No, it will only go up.
So you're where you are. So either you accept that offer or we set your case for trial. Once your case is set for, hang on,
I want a new lawyer. I don't.
hold on. I understand, but
You
listen,
want to let me speak, man? Please, can I speak?
I'm
please?
going to let you speak, but I'm going to give you what your options are, okay?
I just want. All I want is a. What I'm saying, you trying to say trial, this and that. I haven't even seen my discovery evidence. You saying he's a good lawyer, but he haven't even shown me no evidence. So on my case, how can you speak and say he already told me the other day that he working for the DA? He
I'm
already said.
sure
When I said you haven't. He have not one asked me what happened. He haven't even got my side of the story. Have you got my side of the story? Have I told you what happened in this case? Can you tell this person what I told you?
Mr. Larzo, you're not in charge and you're
I'm
not
not saying
asking
I'm not in
questions.
charge, but what I'm saying is, how can he say he can represent me and he's ain't done nothing but come to me and say the DA said this, the police report said this. He has not.
That's the evidence. That's what he's telling you the evidence is what's in.
That's what the police report said, but he hasn't asked me my side. It's a.
And here's the thing, your side is important if you're going to, if you didn't do it, what his job is to tell you this is the evidence they have against you. You can take this deal, or if you say you didn't do it, you can go to trial. So if you're saying you didn't do it, then let's get a jury to determine if you did it or not.
I haven't seen no police report. I haven't seen no body cam footage. I haven't seen no evidence to where I can tell you if I'm ready to go to trial.
Is there media in this
Judge,
case?
if, as Mr. Rojas does in every case, he has requested and reviewed the discovery well in advance.
Do you want, let's do this. Do you have this in media?
Judge, I have requested the media, what I told Mr. Larzo yesterday, when he told me he wanted to watch the video, I told him we could reset the date to look at
Sure.
the video. He just said he didn't want to do that. He just wanted to come in and ask for a new lawyer.
I want to because you now represent me effectively. You come to me and tell me the DA said this.
Mr. Larzo, he's just said that yesterday he would
I
bring the
haven't-
video. Don't talk over me. He would bring the video for you to watch. I'm going to reset your case for 2 weeks. He's going to bring the information. You can watch it and you can make your decision. The offer is what the offer is. The DA's already said that. I don't care if you take it or if you don't take it. Take it, fine. Don't take it. We'll get your case set for trial. You need to be respectful.
I'm
Mr. Rojas is going to get out there, show you everything. You don't get to keep copies of things by law. He doesn't get to hand you a police report and you keep it. That's part of the law. So he can go over that with you, read what it says to you, show you the video, and then you can make your decision. Go back with the bailiff.
May I ask a question,
Go,
please?
nope, I'm done today. Go back with the
I'm not
bailiff.
understanding how you
Let's
can
go.
give somebody 4 years for an aggravated charge
Let's go.
and try to offer me 5 years for non-aggravated.
Actually, he's not happy with this.
DeMarcus Elam, wait, hold on, Mr. Burbank, what are you doing on, Mouton?
Hi, Mr. Mouton,
I know, what's the announcements?
I'm still on discovery. I just got appointed and I've talked to her. I think also based on that, I may need to have her evaluated somewhere between here and there. My request, based on the circumstances.
What?
Evaluate.
Somewhere between here and there?
Yeah, well, my motion is here between here and there. It's the evaluation. It's coming.
Okay.
Today or tomorrow.
Okay, we'll reset this Mouton.
And I've talked to her. She knows what's going on and
All right, yeah, if you'll make sure you get that in,
She's
we
happy.
will get her, evaluated as quickly as
and
possible.
maybe I can convince Mr. Smith to.
DeMarcus Elam,
Just
yeah, DeMarcus Elam. Mr. Smith, you've got DeMarcus Elam, written hearing. Good morning. Are you DeMarcus Elam?
Yes, ma'am.
And this is cause number 26, DCCR 1221. Mr. Elam is charged with the first-degree felony offense of murder. And Mr. Reynolds was appointed as attorney. Ms. Holmes is stepping in to help out on that as well. And they have filed a writ requesting for a reduction in Mr. Elam's bond, which is currently set. Oh,
Yes.
oh,
Yes, I believe Mr.
did I
Elam-
know that ahead of time?
I'm sorry if I didn't make that clear.
No, I guess not, because I'm not gonna, so here's the thing, when you have an attorney, you don't get to have what we call dual representation. So if you, and I don't mind,
I think if I could clarify, it was filed pre-indictment. I'm not sure when Mr. Reynolds was placed on it, but Mr. Elam had filed the writ prior to being indicted, and then after the writ was filed, his case
was indicted.
was indicted.
So it's been indicted at this point.
Yes, ma'am.
Okay. So here's what I'm going to do. What's the bond currently set at?
2 million.
Okay, so what I'd like to do, I'm not going to, because the case has been indicted. At this point, a writ is probably not the appropriate, tool. I would think it would just be a motion for a bond reduction. Ms. Holmes can talk with Mr. Reynolds. They can get that filed. They're going to file things on your behalf, okay? And so I understand that you were waiting on an indictment but that's been taken care of now. But you don't get to file something if you have an attorney. I'm going to take what they filed. So let's get a bond reduction. Ms. Holmes will get that filed for you. I'll reset the case 1 week, but I think we need to have the appropriate tool moving forward legally. Let's do 2 weeks, and we'll have a bond hearing. If the state has any evidence, that'll give them some time to bring anybody, if you wish, on a bond reduction hearing. Okay, so we'll see you back in 2 weeks.
Okay.
Yeah, yeah, yes, that. Yeah, I complained yesterday, but I called them, so they obviously, well, they said something about they would lock open the bench. So apparently they have access to do something to open and close the vent. I don't know, but I mean, that's what I said. Well, I've got the thermostat but down, but it's going up. And I heard them saying in the background, okay, well, we'll do something with the vent. But now it is chilly, but I'm not gonna complain because. See, Mr. Parker, you've got Edward Godfrey. It's a sentencing.
Edward Godfrey.
Good morning. Good morning. Are you Edward Godfrey III?
No.
And Mr. Godfrey was previously here in cause number 26 DCCR 0383. Entered a plea of guilty to assault family violence by impeding breath or circulation. I've received the pre-sentence report. Have you both had an opportunity to review that report?
Yes, ma'am. Yes.
I'm sorry.
Yes, Your Honor.
Are there any additions or corrections?
None more, Judge. Nothing so.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 6 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. This is such an excellent opportunity for you. You're very young. You do not want a felony conviction on your record. It'll change your life in a very negative way, in lots of ways. You can't go to obviously certain jobs, schools, apartments, it just all kinds of things. And so part of your probation is going to be that you get your GED or finish school, one or the other. So if you're not going to go back to school, then you have to start that GED process within 30 days of today. That's not just for me, that's for you. That'll make it also everything in your life easier, getting better jobs and things like that. It's very important. It should be important to you. So I want you to get that done. You're going to go through some classes. You're going to do everything you're supposed to. Then at the end of your probation period, if you're successful, the case is actually dismissed. You never have a felony conviction. The other side of that, though, is if you do violate any condition of probation, you can be brought back into court, found guilty. So you would be a convicted felon and you could go to prison for up to 10 years. Do you understand?
You good?
You understand? And also, it is a condition of your probation that you have absolutely no contact, communication in any way with Ramsey Howard. Do you understand? Okay. All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. All right, good luck to you. You can go back with the bailiff. Marvin Watts, Mr. Parker.
Good morning, Your Honor.
Good morning.
Mr. Parker.
Do I have,
He signed on your spot on one of, but I'm just fixing it.
both cases or just one?
Just one.
He's paying on both cases. He signed.
He just signed one spot.
Oh, because I don't see any here yet.
Yes.
Okay.
Listen.
All right, sir, are you Marvin Lee Watts?
Julie.
One defendant begged for another chance, saying she wanted to change for her children, but the judge looked at 7 prior probations, repeated thefts, and new crimes committed just months after receiving felony probation. In the end, the court sentenced her to 15 months in state jail, while reminding her that every new offense would bring harsher consequences. This wasn't just another theft case. It was a courtroom warning that some opportunities don't last forever.